So first thing I have to say is that YOLO is a lie. Okay, YOLO is you only live once, and that is a lie. Okay, the truth is you live every day. Every day that you wake up, you have an opportunity to live and start a new day and do better than you did the day before. So the truth is you live every day, but you only die once. Not that you only live once. You live every day, but you only die once. And so your estate plan or your succession plan is what are you going to leave behind and how are you going to leave it behind, right? So last week we talked about the most popular trust for setting up an estate plan is going to be a revocable living trust, which is a trust that allows the grantor to maintain control of their assets during their lifetime while specifying how those assets should be managed and distributed after their death. It can help avoid probate, providing a smoother and more private transition of assets to beneficiaries. So some of the benefits of an estate plan is going to be you get to nominate who the guardians of your children and who or your pets are, right? So first of all, if you don't have a will and testament, a final will and testament, then the government, the state, gets to decide who takes care of your children and or your pets, right? If you do have a will and testament, but it's not inside of a trust, then it has to go to probate, and there could be a period of time where it's deliberated who's going to have authority to take care of your children. Now, you think that it's not a big deal in that, well, obviously these are my children, and they're going to go to this person or that person. But if you don't have these details defined, then it is up to the opinion of the state who is going to be the best person to care for your children. Another scenario could be you have family members who are contesting, maybe an aunt and or a grandmother, either one or two different aunts want to take the kids, and now they're fighting over who's going to take the kids. So you need to know, you have to have this in writing in your will and testament, and you have to have that will and testament in a trust so that it doesn't have to go to probate and your word is bond and it immediately becomes effective. Okay, so that's number one. That's the number one benefit. Number two is you decide who will handle your affairs, right? So there's going to be a power of attorney given to somebody that's going to be in your will and testament. It's going to be in your trust. And that person is going to be the person who handles your affairs. When you go, you're going to have business loose ends. You're going to have potentially debt loose ends. You're going to have investment account loose ends, asset. So you need to have someone in place who's going to be the person, the go-to person who has that power of attorney to handle your affairs. Now, you may also want to leave specific gifts like money and possessions or property to people and or nonprofits. All of that can be defined in your estate planning trust. You'll be able to determine how your assets will be distributed. Again, you control that, and by putting that into your trust, it does not have to go to probate. You'll also be able to define specifically any people or individuals that you want to exclude from receiving any property. That's just as important as defining who you want to receive property. You'll be able to specify your final arrangements. So this would be your funeral arrangements. Do you want to be buried? Do you want to be cremated? Do you want to have a concert for your funeral, or do you want it to be, a quiet, funeral where, not too many people are there? What do you want? What music do you want played? What kind of coffin do you want? There's a lot that goes into funeral arrangements, and you're able to set that in place so that your wishes are granted and other people are not making decisions on your behalf as it pertains to your final arrangements. You'll also be able to make sure that you have the funds allocated and in place to cover those arrangements, and that could be arranged in many different ways, which we can talk about a little bit later. You'll also be able to make a note of any special requests, decide what should happen in a medical emergency. So that's your medical directive. So if something happens to you and you're unable to care for yourself and you're unable to make medical decisions, for example, if you're only being held alive by life support, do you want to stay alive, and how long do you want to stay alive for? Do you want your organs to be donated? Do you, what is it? What are your medical directives in the event that you're unable to speak on your own behalf? Who's that person that's going to make those decisions, and that person would need to know what your wishes are, and that all of that can be put into your trust. Um, Again, designate healthcare agents, grant trusted individuals access to your medical records, add conditions to asset distribution. This is really cool. This is where you can literally create if-then statements in your trust. So, for example, if you're leaving a legacy of assets to your children and they're minors, you can say, okay, well, when they become 18 years old, they're going to inherit this, whatever it might be. Let's use $1 million as an example. They're going to inherit $1 million, but they're only going to get access to $20,000 if they have straight A's in school. If they have B's, then they'll get $10,000. So that's an if-then statement that defines exactly how your assets will be distributed, and that can carry on as long as the beneficiaries of the trust are alive based on your directives inside of the trust. So those if-then statements can create milestones for your children and children's children to inherit that wealth. And that's very important. I don't remember exactly what the statistic is, but what it basically said is that for those people that are self-made millionaires, most of their children's children, so the second generation, will have squandered that wealth in their lifetime, and that's because they didn't go through what you went through to achieve those results. They don't understand the value of the work ethic and the good, being a good steward that you had to go through to reach that success. And many times we end up spoiling the next generation, who then passes on bad information to the third generation, and before we know it, the legacy is squandered. So you can control that with if-then statements in a trust, which again, your word is bond in the trust, and nobody can contest that. It is exactly what you say it is. And then finally, as I've mentioned several times, is you're going to avoid probate court, which can cost thousands of dollars and take lots of time. And so, assets inside the trust and your directives inside the trust will avoid probate, which will make your life much easier for those who inherit assets and instructions from your trust. Okay. Some of the documents that are going to be included in the trust are a revocable living trust, schedule of assets, your last will and testament, HIPAA authorization, your living will, power of attorney, and certification of trust. And you also have to, in your life, you want to, make sure that you've set everything in order to transfer the ownership of assets into the trust. And so that way, when your time comes, the attorney will then change that revocable living trust into an irrevocable trust. That then seals the trust, and assets are secured and protected inside of that trust upon your demise. So the revocable living trust is the central hub of your estate plan, with provisions for the management, control, and distribution of your assets during life and after death. Your schedule of assets is a listing of assets that you hold in the trust and are subject to the provisions of the trust. This can easily be updated as you add or remove trust assets, again, because it's a revocable living trust. Your last will and testament, your final wishes for your dependents and arrangements with specific references to the details outlined in your trust. HIPAA authorization authorizes trusted individuals to receive your protected health information for specified purposes. Your living will specifies your preferences for healthcare and medical treatment to be used as a guidance if you are ever unable to make decisions. Power of attorney assigns someone an agent to manage your personal and business responsibilities if you are away or incapacitated. And then finally, the certification of trust provides this document to third parties in place of a copy of the trust. This contains a summary of key provisions from the trust, but does not reveal other personal details. I am not an attorney, full disclaimer, and this information is not meant to represent legal counsel. I have provided links in the description for a legal firm that can assist you, one for estate planning and one for asset protection. So if you'd like to get your estate planning trust set up, make sure you take advantage of the link in the description below for a discount with trust and will to set up your estate planning trust.